Stanley v. Georgia is much more of a traditional privacy case. What I mean by that is when we think of privacy, when the average individual thinks of privacy, um, they don't jump to things like marriage, procreation, um, birth control. That's not immediately where most individuals' heads go when they hear privacy. They hear privacy and they think of being private within one's home. In Stanley v. Georgia, absolutely is the example of what privacy within one's home looks like. Um, and so this is a classic case. In this particular case, Stanley was served a warrant um, to search his home for purposes of finding gambling and bookmaking evidence. Bookmaking being um, gambling on sports, that sort of thing. But in the context of the search, in the search for these devices, obscene films were found, and the defendant was charged with possession of things of an obscene matter. Um, this isn't, in 1969, this is at least notable. Betamax doesn't exist, VHS doesn't exist. What we're talking about in this case is this individual within his own home had reel-to-reel pornography. Literally, they had to set up the reels and project it that way. But the state finds said material and charges him with possession of obscene matter. The Supreme Court has a lot of issues to deal with in this case. But the ones that I want to focus on are the First Amendment and 14th Amendment parts of this case, because we could also deal with whether the search was, whether the evidence was found was legal within the search. But we're not dealing with that in this context. We're just dealing with the First Amendment and 14th Amendment protections in this case. The Supreme Court in this case, citing the First Amendment and the 14th Amendment, overturn this conviction and strike down the law in question that allowed this conviction. So let's deal with the First Amendment portion. What is the First Amendment portion in this case? Like what part of the First Amendment do we use to get to this case? It has to do, at least in some contexts, with speech, but it's also associational. There's a lot of First Amendment context to this case. But the 14th Amendment part is absolutely more fun. So the court articulates that it is a fundamental right to be free, except in very limited circumstances, from unwanted government intrusion into one's privacy. So the court articulates that individuals are private within their home, except under limited circumstances, being warranted searches and what have you. In the previous cases, understand that privacy was revolving around the idea of marriage and procreation, but very clear here, the court carves out another area that individuals are free from government intrusion into their home. And the court says that if the First Amendment means absolutely anything, it means that the state has no business telling a man sitting alone in his house what books he may read and what films he may watch. And so that there's certainly a First Amendment aspect to this case. There's also the broader privacy aspect to this case. And the court very clearly includes privacy of one's own home within that. And so privacy in your home is fundamental except for certain protections. So the ability to have obscenity in one's own home is protected up until a point, and that point usually being things like child porn or other sorts of obscene materials that puts other individuals, and especially helpless individuals, at risk. And so those sorts of limitations are absolutely okay. but the general prohibition up against having obscene materials in one's homes is absolutely struck down in this because of First Amendment grounds and because of 14th Amendment grounds. But what the court really hasn't done up to this point is articulate an expansive view of what privacy is, not within these cases at least. And that seems interesting because the case in which the court articulates the most broadest view of what privacy is, and also more importantly, where privacy comes from, happened 4 years prior in Griswold v. Connecticut, a case of which we will deal with in the future, literally the next class period. Before I give a discussion, at least at some extent, about what substantive due process is and how substantive due process has evolved over time. These first 4 cases that we did don't deal with substantive due process. And it's absolutely important to understand substantive due process and what substantive due process is before we start getting to the nature of the right to privacy and how the right to privacy gets written into this Constitution. Because these last 4 cases, you didn't need the right of privacy to make those decisions. In Stanley v. Georgia, you didn't need the right of privacy to say that the First Amendment protects an individual to have what he wants within his own home. Though there's privacy aspects to it, you could make that decision on other grounds. Same way with Skinner, and the same way with the other cases we've done up to this point. But once we get to Griswold, we absolutely need the nature of substantive due process to discuss it. So I'm going to leave off here today. We'll discuss substantive due process in the next class, and then we'll get in the next class to Griswold v. Connecticut, which really opens up the window of how the right to privacy exists within the United States.